Thanks so much for joining us. And joining us now on the line, Christopher Green, law professor at Ole Miss. Professor, how you doing today, sir?
Doing well. It's quite exciting. I was just asking some of my appellate litigation specialist friends when we can expect this lottery result. They said, "Do it when they do it." So it's one of the most exciting appellate litigation federal courts days for that kind of arcana.
So, Professor, for the benefit of our audience, can you kind of walk us through this sequence of events, how we got to where we are? We had lawsuits filed, right, that we had a court of appeals rule on, and then, if I'm not mistaken, there was an appeal to that, right, which got struck down.
Yeah, well, so the way it works,
okay.
When an administrative agency like OSHA does something, okay, so we got the Occupational Safety Health Administration. They come out with this rule for any employer bigger than 100 employees. Everybody's got to get vaccinated or get fired or have some kind of testing regimen.
Yeah.
And there's two things you can do at that point. One is to file a lawsuit in a trial court. So there were some lawsuits filed. Several states got together in one of the district courts, the federal trial courts in Louisiana. Attorney General Fitch was in on that. Some other folks, Aaron Rice, with some private parties were in on that lawsuit. So that's in a federal trial court, and that's challenging both the OSHA mandate and the federal contractor mandate. Lots of issues there. Another thing you can do when an agency does something is you can petition straight to a court of appeals. So we have 12 different courts of appeals. The Fifth Circuit is our circuit, Mississippi, Louisiana, and Texas. And they acted in response to their petition. But there's a procedure if there's more than one petition for the same administrative rule, and they go to different circuits, so they file petitions to review this rule in different circuits. Basically, they wait 10 days to see how many circuits it gets challenged in, and it turns out it was in almost all of them. So the First Circuit, the Second Circuit, all the way up to the 11th Circuit. The D.C. Circuit also has a petition, and there's only one circuit left because it only deals with patents and suing the government for money damages, the Federal Circuit. So we got these 12 circuits, and the rule, there's a statute. So if you're looking for music to listen to, you can listen to the Rush song 2112 because that's the section number, 28 U.S. Code 2112. And it says they wait 10 days, see how many petitions, and then they have a randomly selected process done by the MDL, the Multidistrict Litigation Panel. And this is purely random. They have special rules that they say they literally put ping pong balls in a wooden drum. And they pick it out, and they're going to tell us which of these circuits they go. So now the Fifth Circuit has already said we think this rule is probably unconstitutional. None of the other circuits have acted on it, but because the Fifth Circuit acted, there wasn't a whole lot to do. But the Section 2112 explicitly says that when we find out who wins this lottery, that circuit can vacate, can basically undo a stay that any of the other circuits had done in the meantime. So it's explicit in the statute that this Fifth Circuit decision is going to be subject to being undone by whatever circuit gets us. And, of course, after that happens, you can go to the U.S. Supreme Court. And this seems, I would think, about as likely as anything to be a pretty clear slam dunk for the Supreme Court eventually looking at this. It's possible the lower court will be sufficiently clear in its reasoning. The Supreme Court might say, well, we just agree with that. Yeah. But I would think the Supreme Court is going to look at this before too long.
Wow. So it's my understanding, Professor, that once this lottery is drawn and venue, I guess, at that point is established, that all future cases also would be heard by that court?
Yeah, so they get all of the petitions then get transferred, all the petitions for review.
Okay.
So we've got the lawsuits. So basically you file a lawsuit in a federal trial court when you have possible fact-finding. So the Fifth Circuit, they're not going to hear witnesses. They're not going to look at – you're not going to have a deposition that you file at the Fifth Circuit or anything like that. So if you need fact-finding related to the legality of a petition, you have to do that in the district court. So that litigation can still go on in just all the district courts. But then all the petitions get consolidated in that one lottery winner, and they'll make the decision. And so the first thing they'll do is decide whether to stay the rule, and that immediate decision on the stay would be subject to review at the U.S. Supreme Court.
Okay.
So we would get, and the Supreme Court doesn't have to say anything about it at that point, but when whoever, either side goes to the U.S. Supreme Court, if any of the justices want to say what they think about the constitutionality or the consistency with the OSHA statute, they can do that then. So it's pretty likely, I would think, here within a few weeks, certainly within the next couple months, what the U.S. Supreme Court thinks about it.
Do you have an opinion on it, Professor, what the likely outcome would be?
Well, there are a number of challenges. So one big interesting doctrine, which the court has indicated they're interested in looking at again, is something called the non-delegation doctrine.
Yeah.
So this is a doctrine that was used in 1935 to strike down two very big statutes in the New Deal and hasn't been used by the Supreme Court in any other year. But the Fifth Circuit, in their opinion from last Friday, said we think that this has serious doubts about the constitutionality under non-delegation, whether Congress could do this.
Yeah.
So that would be the biggest, most, from my con law teaching perspective, the most exciting or interesting, maybe frightening for people who are worried about their administrative state getting struck down as unconstitutional. I think it's more likely that what they'll say is, well, such a big question is this. It's not a transfer of legislative power to the executive, but it's such a big question we would expect Congress to be explicit about it, and they haven't been explicit in the OSHA Act, so we're going to construe the statute to say they can't do it. So that's called the major questions doctrine. I would think that's probably the most likely outcome. There are also some just administrative law things. You can say, well, they should have had better notice and comment before issuing this rule. They should have given better answers to counter arguments. So there's something called Overton Park arbitrary and capricious review. Either of those are a possible way to resolve it. But there's a bunch of hurdles that the administration has to get over. It seems relatively unlikely that they'll get over all of them.
What about this grave danger?
Things have happened.
I'm sorry. What about this grave danger legal standard?
Well, it's so that's some language that they used in. I think the OSHA Act has some. Some language like that. The idea is, if you're at a workplace and you've got a big buzzsaw that's, unnecessarily dangerous, if you think of the triangle shirtwaist fire, that kind of circumstance where people have blocked exits, they can't get away, of a dangerous situation at work, that's the sort of condition that causes the early 20th century workplace regulation stuff to get passed. So the OSHA is coming in that kind of environment. And it's not obvious that a virus getting spread at work or spread among people who are at work is a perfect fit. One problem with the administration defending it is saying, well, a virus is kind of like a fire, is that the rule doesn't make any consideration of, for instance, how many people are in a workplace, how close they are.
Yeah.
Are they all in their own offices? So I'm right now in my own office, and the mask mandate we have at Ole Miss only applies when I step out into the hallway. And it would be a very different workplace if I had to wear my mask even when I'm in my office. But, in terms of vaccination requirements, there'd be, obviously that's not going to change depending on, where you are in the building. But how likely is it the particular employee is going to spread
Professor, we got
coronavirus?
We got a break right here. Can you hang with us? I want to talk to you a little bit more about this in the abortion case.
Oh, sure, yeah, that's coming up too.
We'll be right back after the break with Christopher Green, University of Mississippi Law Professor. Days, Gerard and Will in the studio. We've got Christopher Green. He is a law professor at Ole Miss. So, Professor Green, before I ask you about these abortion cases, you're probably aware that the state of Mississippi has also joined several other states in suing the Biden administration, I think 12 other states, on vaccine mandates for healthcare workers. I think specifically that applies to healthcare institutions and workers that work for those organizations that also participate in Medicaid and Medicare. So there's really two aspects of the vaccine mandate issued by the president. There's that piece for federal contractors, it's federal contractors, and then there's the piece for private employers with more than 100 employees. I think this refers to the former, right, that this deals with, I guess they're construed as contractors, a healthcare institution that participates in Medicare and Medicaid.
That's right. There's two different provisions for contractors. One is specifically under Medicaid, which has had kind of a long history since 1965, and the other is a much more general federal contractor. So Ole Miss is subject to the federal contractor rule in general because we have all this federal money that comes in for different things. But the healthcare workers is specifically with the Medicaid.
Mm-hmm.
Both of those are being challenged. Basically, the argument is that requiring vaccines is not germane to the funding of whatever the activities are. So the arguments are going to be a little bit different for every individual piece of federal funding. So, for instance, we get money from NOAA, the National Oceanic Administration, and that doesn't have anything to do with vaccines. So the argument that would be, that a restriction for that contract would be germane is a lot harder to make than for healthcare workers, and having healthcare workers who are constantly exposed to people who are sick. Well, there's obviously a different argument for germaneness, but the big precedent in both of those cases, I think, is this Enford versus Sebelius case from 2012, when they struck down the Medicaid expansion. They said you can't tell states that it's all or nothing, expanded Medicaid or no Medicaid at all, because the threat to cut off the old Medicaid doesn't have any purpose other than coercing the acceptance of the additional offer, and that's not germane to the original Medicaid. So it opened up a new era of attacks on conditional funding schemes, and that's, I think, the basic area of law that those lawsuits will be considering.
Well, it'll be interesting to see how all that plays out. So, is that another suit that would I guess be heard and come before the court in whichever is decided upon by this lottery?
No, so that would not be, I think, the lottery.
Okay.
I haven't been following all of the different suits about the contractors, but I think most of those have been filed in district courts, or maybe even all of them, because there's a need for fact finding.
Okay, I got you.
So because you need to find facts, you can't just go straight to the appeals court. Mm-hmm. So the lottery today, that's going to be the OSHA mandate for employers, all employers, whether they've done anything related to the federal government or not, above 100 employees. Mm-hmm. So that's the thing that the Fifth Circuit has put on hold, and which we're going to find out at some point in the next few hours what circuit is going to take it. But somebody I know on the Twitter who pays a lot of attention to composition of the various circuit courts. He tweeted out a list of which circuits are most likely to have the OSHA challenges succeed and which going to be least. So he lists the 5, 6, 8, and 11 as the most likely to be favorable for the challengers. 1, 4, 9 in D.C. is least favorable, and in the middle, 2, 3, and 7. And I think he'd probably put the 10th Circuit. 10th Circuit had was a late entrant. So at one point they said all the regional ones except 10th. And it's like, oh, we've even got a 10th Circuit one. So,
well, how long has this lottery process been around? I'm sorry to interrupt, Professor. How long has it been around? I mean, has this been used before? I've never heard of this before.
So I got to confess, I had never heard of it myself before last week. It has been around since 1988. Before then, you had essentially a race to the courthouse. So the first people to petition the first court to get a petition would be able to hear it. An awful lot of these petitions are heard by the D.C. Circuit.
Okay.
So that's a court that is in D.C. You have to have some kind of factual hook to have a regulation being made on you in that circuit. Okay, so if they're doing things in D.C., it's just easier to establish that for the D.C. Circuit. But also, you're just closest. The people who are day in, day out knowing about the regulations that are coming down the pike. It's much easier to file those in the D.C. Circuit than any of the other ones. So I think they won a bunch of those races before 1988, but they thought, well, let's have a lottery. And in general, in the 80s, a lot of people thought there was too much of the federal administrative apparatus in the D.C. area. It's still a massive amount of it. You go to Northern Virginia, my goodness, it's practically a wholly owned subsidiary of the federal government. Huge areas, but and it's always getting bigger. But some of the growth of the government has been out in the provinces.
Yeah. It's just, I even discussed it with a couple of attorneys I work with and asked them. They'd never heard of it either. So if you have a professor and they have it and your profession has it, it just made me wonder, when's the last time this ever came up? And what is unique about this situation that requires it?
Yeah, it's basically the fact that it's they try to streamline the process to just go straight to the Court of Appeals to have a petition. And when you tried to streamline it, it produced a race to the courthouse. So once they had that race to the courthouse phenomenon, they thought, well, let's not just get the input of the D.C. Circuit all the time. Let's get the input of these other judges as well. So it's administered by this thing called the Panel on Multidistrict Litigation, which has been an increasingly important part of federal courts. So I actually decided I'm going to add a page of my notes to my federal courts class just specifically about the MDLs.
Yeah.
A lot of attorneys in Mississippi, you may have heard, of spending a lot of time up in West Virginia because they got a big MDL related to some medical litigation. That there's some people on the coast that do huge numbers of these cases, but the initial stage pretrial stuff is being handled by a district court in West Virginia. So it's like, well, we're going to fly up there quite a bit. And some of the judges say, hey, if we could get an MDL here, we could get people to fly down to Mississippi. But that process for the trials is that's related. There's a bunch of decision making related to the subject matter. The lottery is like literally just a ping pong ball.
I got you.
But the MDL, it's a much more complicated process. And I'm gonna teach my students starting next year much more about that.
We got a couple of minutes left. All right. So what about? Let's turn our attention to these abortion cases, of which Mississippi, of course, is front and center as a party, as a plaintiff in that. Well, what do you think?
Well, it's I was just in D.C. this last weekend with the Federal Society group, and there was a lot of buzz. People are wondering about it.
Mm-hmm.
I don't think people have a lot of information. So, the Supreme Court itself has historically just been, heroically tight-lipped in terms of, you just don't know anything about what they're thinking. So, one thing we're wondering is how upset are the justices going to be that the merits brief that we filed was so much more aggressive than the cert petition.
Yeah.
So that's one question that's certainly going to come at Mississippi out of the box is why is your merits brief so much more aggressive? And the answer is probably going to say, well, the court itself turned down 2 of the questions presented, and they only granted the question presented that was the most general. And reevaluating Roe and Casey is encompassed in that, so that's why they did that.
I got you.
Straightforward way to do it, but it's hard to know. But it's just a couple weeks away, so
yep.
we'll see shortly.
We'll keep an eye out on it, and hope to get you back to talk about that some more as we get into that and some of this other stuff happening with respect to this lottery. We appreciate you coming on, Professor. It's been a good discussion. Thank you, sir.
Enjoyed it.